Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. Woo! So I was up checking my emails and I got an email from Tooth. Let me not mess her name up. Human Tooth X, and she was on WebEx during the trial, and she saw that I missed the first 2 hours, and so she was like, "I posted the opening statement on Reddit. Feel free to use it on YouTube." And then so I went to look at it, and I something told me, read the comments, and then I saw people are waiting for updates from me. So I am going to do. I have my notes, so I will go over that. But again, I was there in the second half. But I want to start with her opening statements, and she has graciously offered for me to use them. She also said she has the full recording, so I asked her if she wouldn't mind doing the 2 hours because I got there at 3:30. So the 1:30 to 3:30 is what I'm missing. And because she said in her email that she was going to do all four and redact the PII and the child's name. And I'm like, I only need the first two. So hopefully she'll give those to us and we can react here together. Yeah, let's go into the opening statements and then I'll go into my notes. I want to clarify because she dialed in via WebEx. There was also just a telephonic dial-in, which now I'm thinking is probably just the one that WebEx will provide because Sarah was not there via WebEx. There's no opportunity for her to be on camera. Human Tooth confirmed that she could see the judge and the judge's face on the WebEx. So take that for what it's worth. After we were doing our notes, some of the others were saying, "Oh yeah, I saw a WebEx dial-in," and I was like, "Oh, I didn't see that." I'm also rocking. Larry Powers gave me this El Paso Tejas mug while we met, so I'm rocking the El Paso. Thank you, Larry. All right, let's get right into this. Oh, let me run the intro. I'm so out of sorts. Thank the members. Thank you for being here. If you like the content, please hit that thumbs up button. I appreciate you. Before we get into this, I want to say it's 7 o'clock in the morning on Wednesday, August 27th. Sugar Bear is here. He's watching Jurassic Park style dinosaurs. If he comes in here and that bothers you, just click out of the video. You don't have to leave a long note about it. There are no childminders at 7 o'clock in the morning. So anyway, I know some of you enjoy him, so that's not directed toward you. Let's get into this.
All right, Ms. Boone, would you wish to make a opening statement?
I will do my best, Your Honor. I said I will do my best. Thank you for the opportunity.
Okay, you may proceed.
First off, I would like to say that I am having to represent myself. I am pro se. I am not an attorney. I am not educated. I have not gone to school, and I'm doing my best with the limited resources that I do have. And
yes, you heard that correctly. She is not educated. I don't know why she feels the need to say all of this because the judge knows that you're incarcerated. So even if you had been an attorney previously, you can no longer be because you're, as found by the state of Florida, a murderer. So, okay.
also, when the petitioner and his counsel decided to include me on documents and whatever exhibits and evidence it is that they are proposing that they have to present to you while in the courtroom, and I am here on the telephone. I also would like to say, please, Your Honor, that the evidence that they are trying.
So, also a waste of time. Obviously, we know you're there on the telephone, Sarah, because we can hear you. We can see the phone number up on the screen. Maybe she thinks she's making a record of this, but it's already in the record because the judge has an order for her to appear telephonically, and also on the record is her motion to appear in person, which they will address after, well, maybe, because I haven't watched all of this. They either address it in opening or right after opening. The judge gets Sarah to agree to dismiss it, but she's already out of the gate struggling.
to hold against me in regards to the $600 storage unit, the $370 child support, the attorney's fees. A lot of these things could have boiled down to simple communication. Would they have taken advantage of any of the mediation opportunities that were presented by the court? That a lot of these could have been resolved, including the temporary location that could have been discussed and proposed and agreed upon. Also,
So the temporary relocation has already been sorted out. They moved in 2023. We're in 2025, so I'm not sure. So mind you, these are meant to be her opening statement. She's meant to be laying out what the evidence will show in the trial, what evidence she plans to present. So far, it's just complaints. It's just how she's uneducated and, by herself. They're trying to take advantage because Brian has been paying $600 and also been paying child support. Apparently, we learn in here that there's $4,000 being held. That's the money that she wants. She's agreed that it should go for the child, but she should be designated, or she should be the person designating where that money is spent. Which, I don't know, it reminds me of the game, when, I don't know where they have them now, but you pick a prize with the claw machine, she's just picking up because she's far removed from what's going on in his daily life. So is she going to designate it to little fish soap?
What are you talking about, ma'am? Anyway.
She's going on about a mandatory meeting. She's talking about that again. She put that in her 33-page rant. That has already been addressed by the court. They were admonished for doing that. They should have come forward to the judge and asked for permission.
But they felt like forgiveness was better than permission.
So she's going on about that again. Again, this is opening statements about what the evidence will show. There's no reason for this mandatory meeting to be discussed right now. None.
another opportunity could have been had in the mandatory attorneys meeting and unrepresented party meeting that we were supposed to have pre-trial conference before that. And again, the defiance is not in myself, as I have been 100% transparent, cooperative, and trying to do my best with whatever it is I can in order to prove my side and the truth.
I love that her side is separate from the truth, her side and the truth. So if being in, I want to say this too, Human Tooth did a spreadsheet. I need to ask her if I can show you guys it. But so when they originally asked for mediation, that's when Sarah announced she had cancer and who picked the mediator and just like a list of questions that needed to be answered. And what if she had to have her date changed due to her cancer? Basically asking the dude for legal advice, which he cannot give her. But so that was not cooperative. Only in Sarah's mind was that cooperative. But Human Tooth did a tally of like how much it would have actually cost if the lawyer had gone through and sorted out all of her requests, which I think is funny. So it's possible that she's saying all this to backhandedly say, I shouldn't have to pay for attorney's fees because this is their fault. And not understanding like how she has dragged all this out. Even the fact that she's mentioning the temporary relocation today, other than to say, I give it my blessing, shows that it's not resolved in her mind, right? She's saying it could have been done differently. And there's a thing you'll see, because later in there, they talk about she's not being included. And he was like, there's been no major things to include you in. And she's like, well, what about COVID? And apparently Sarah didn't want the child to be vaccinated and it terrified Brian, so he immediately got him vaccinated. So they had a conversation about it, but it seems like in Sarah's mind, if Brian doesn't agree with her, they haven't had, like she hasn't been consulted. Do you know what I mean? Like there's a difference between a conversation and being forced to do what Sarah says. So who is like the referee, like, and calls it which party is right is the kind of the scenario that she's coming up with.
and to show my adamant intentions of being included in my son's life and trying to approve what it is that I have been legally entitled to in regards to alimony and any arrears attached to that. The defiance is coming from the petitioner and his counsel by not abiding court-ordered payment.
So she still doesn't understand. He is not obligated to provide court order payments. The moment that he filed that motion for elimination or reduction of alimony, the arrears, we've talked about it before, there's the 2 years in question, and we'll get to that throughout as we talk about this, but he's not required to, which is why they wouldn't hear her motion for contempt. He's not in contempt until his motion is heard.
And any other court orders in regards to the parenting plan and anything else that the court has proposed as of the official divorce. And that's including also attorney fees, which are self-inflicted when they have been truthful and ethical in providing the proper paperwork and a proper amount of time.
So she just called them liars and unethical, intentional or unintentional. I think it's intentional, but she just said they've not been truthful or ethical. That's a
Them's fighting words, y'all.
So I can actually review and correspond timely with the correct information.
Ms. Boone, you're way off base here. I need to know, an opening statement is kind of a outline of what you intend to present at trial on the issues regarding the parenting plan proposed for the relocation and the modification of alimony and child support.
Is my motion for contempt also included at some point?
No, ma'am, I've already dealt with the motion for contempt dealing with the application. Again,
So Sarah is talking about her motion for contempt that I just mentioned, the one where she wanted him to be found, Brian to be found in contempt of court for failing to pay alimony, right? But that was on hold until his motion was heard.
I've told you what the issues were that we're here on today. You may continue, but let's talk about those issues. What do you intend to present as your evidence and your position regarding the relocation proposed parenting plan and the modification of child support, the modification of alimony, and the request for sole parental responsibility? Those are the issues that we're dealing with right now.
Yes, Your Honor. I was asking in regards to the motion for contempt in regards to alimony that does not have a judgment and has been continued up to this point. That was my question for the motion for contempt.
All right, ma'am, continue with your opening statement.
Has the court received my exhibits, please, Your Honor, that I sent?
We're not talking about exhibits right now. We're talking about your outline, your overview of what you intend to present to the court today.
What my case law and my exhibits that I'm hoping that you all receive.
You can continue with your opening statement.
Other than what I've actually already said, Your Honor, I'm not sure what I'm supposed to be doing, to be honest with you, so
Here, I'll stop for just a minute. Let me give you some guidance, okay? They are requesting that you have one visitation per month with the child and one phone call per week. What do you intend to ask this court for as far as contact with the child?
Okay, yes, please, if you don't mind, I'm going to pull that from my pre-trial statement.
AKA the 33-page rant.
Thank you, Your Honor. My request that I put in my pre-trial statement were to have daily telephone calls, if I would like to have them, with my son, which he would like to have as well. Personal space and funds already added to the phone, so there's no interruption, please.
So the question is about the frequency of the contact, but of course she goes beyond that, right? And she's adding personal space, which I'm not sure how the judge could grant that. What does that even mean? Does he not have personal space now? Does he need more? Funds already added to the phone. So now she's asking for money, right? That has nothing to do with the contact she wishes to happen. And if she can't afford to talk to him every day, then she can't. And to ask Brian to do it, which is low key, high key, what she's doing, so there's no interruption. What does that mean? So that every day she can call when she wants to, there's no interruption on when she would have access? I mean, I love my mom dearly. I don't talk to her every day. I don't have time to talk to her every day. She doesn't have time to talk to me every day. And there's not enough change from day to day. Do you know what I mean? Like we have a long distance relationship. We talk about significant things. What things of significance does Sarah have to talk to anybody about every day, let alone her 14-year-old son?
Please have the credit for he and I to be able to correspond with one another and utilize the features of the tablet to stay in communication.
So this was the first I was hearing about, the Monday was the first I was hearing about any of these extra features in the tablet, but they will come about throughout, which is how she gets to her estimate, I think, of like $250 she needs a month. She claims it's an estimate of what she's paying, but Brian's attorney digs down on that and unpacks it, so to speak. But yeah, apparently there's more features. I don't know if it's like emojis or what else could the tablet have other than texting, but apparently she wants money to pay for that so she can experiment, I guess, with these extra tablet features.
Virtual visits on the kiosk. The in-person visits, I put 1 to 2 per month with a maximum allowable time afforded by the correctional facility.
So in-person visits 1 to 2 per month, and then virtual visits on the kiosk. She doesn't give a number, but let's give her the benefit of the doubt. Let's say it's 1. That's 3 times her son has to sit down and visit with her. 2 times that Brian has got to drive like an hour and some change each way. So it's a lot. It's a lot, in my opinion.
Please. I would
Okay,
like to
2
have
in-person, hold up, stop. I just want to make sure I understand. You're requesting 2 in-person visits for the maximum time allowed?
1 to 2.
Okay. Okay, you can continue. I just wanted to make sure I understand you. Go ahead.
Yes, Your Honor, thank you. I would like to be included in all holidays, including schooling holidays and any other time a minor child would like to include me. I would like to compel the petitioner, please, to
Included in what way? Like Juneteenth, at least here in New York, or is I think it's federal. I don't know. Is a school holiday, is a national holiday. How would he include her? Like he has to talk to her longer, it has to be a virtual visit, they have to have an official celebration. Like she's not specific enough.
include me in any decision making regarding the minor child.
So she doesn't want him to have sole parental responsibility, is what she's trying to say, right? He wants it, she wants to be included. But again, inclusion doesn't mean she has a voice in it, right? Like, because he ultimately has the final say. It's his time, it's his money. He's with the child daily.
To enforce communication, regular correspondence of the petitioner with me and all available options, including phone calls, tablet messages, letters, third-party representatives.
Third-party representative. So she wants the judge to enforce.
I said force when I read the 33-page rant.
That he talked to the flying monkeys, or as hear me out, as name them the idiots. Right? Which I don't think the judge can do jurisdictionally, but even if she could, why would she want to?
The manner necessary, please, that I request, so we can communicate between one another, which has been a huge problem in this entire process. And to please keep the respondent, myself, updated regarding the minor child's proposed vacations, appointments, meetings, any happenings in his life, so I can be included.
So I love that you've written this out. Why do I keep forgetting the name? Something tooth. But so proposed vacations, so I can be included. So it's like he has to pitch her an idea, right? Because if I have a proposal at work, I have to pitch it to someone to get it approved. Why is it a proposed? Like before he books a ticket, he has to consult with you. For what reason, ma'am? For what reason?
To please enforce perpetual cooperation of the petitioner with myself in order to simplify, relieve, prevent ongoing and future problems for myself and the son. And please, to stop his intentional lack of, which he has been doing so throughout this entire case. So please cooperate and
So that's one of those Sarah-isms, and please to stop his intentional lack of, which he has been doing throughout this entire case. Lack of what? Communication? Between you, the flying monkeys, all the tablet messages. We find out later that he's read all the tablet messages. He didn't respond because there was nothing worthy and or requiring a response. I don't know how things could get any simpler. He just doesn't talk to you. That seems pretty simple to me.
just try to simplify things. Include me.
All right, I get the gist of that. They're also requesting that the alimony of $1,000 per month be terminated. What is your position on that?
Please, if you don't mind, I'm going to pull my paper.
All right, you're going to get a chance to present evidence. What I'm trying to find out now is just simply an overview, an opening statement, what the overview is of your position on everything, so that when I do hear the evidence, I know what I'm listening for.
Yes, Your Honor.
Okay,
Thank you for your paper.
I don't need specific language. Are you contesting? Do you believe that you should still be paid $1,000 in alimony per month?
I do, because the orders were active, including arrearage.
Right? Do you believe you should still be paid $100 per month in child support?
I do not. The petitioner.
So her logic is because the court ordered it in 2018, I believe I still deserve it, even though I've been incarcerated. It's like she doesn't get that we're here today to get new orders, right? That his motion is to discontinue it, eliminate it, or reduce it, and to eliminate child support. That part has not clicked in her head. She is sticking to the court ordered it, therefore I'm deserving of it, because later we'll hear his attorney ask, like, you think, because she lists out her expenses, which I'm going to pull those up so we can go through it, because that's the part where I came into the court. But you think Brian should pay for that? And she's like, well, it's court ordered. Yes, so therefore he should pay for it.
And myself came to that conclusion when Judge Dean was on the bench, so that should be concluded.
All right, so you agree that Mr. Boone should not be paying you child support?
Correct. Yes, Your Honor.
They made a statement that there is approximately $4,000 that is sitting in the clerk of court with regard to child support. They're asking that be returned to Mr. Boone so that he can use it.
So this was new information that there was $4,000 sitting in there. And one of you guys reached out and said there are additional checks in the unclaimed checks fund in Florida. I can't remember. I think it's about $1,500 that is not claimed. So I don't know. Maybe someone dropped Brian's lawyer a note that's there so he can get that back as well. But basically in 2020 and 21, when he had a job, there was a wage garnishment. I remember going back through the files beep, and seeing that he had been found in contempt at one point when those payments weren't being made, and then it was cleared, and then the judge, I want to say under not Mauricio Padilla, under Bankowitz, had said that it was okay to stop paying child support pending the outcome of her case. And we've gone over that on the channel.
To care for the child. Do you agree with that?
I do, only if he decides to include me, please, on some of the things that I would like to have my son to have also, and things that he had made mention to me that he would like to have in order to become more of an adult and his growth in his teenage years.
All right, so Ms. Boone, what's going to...
I think this is a perfect example of where Sarah should be consulting with Brian. She should in no way be making purchases for the son without consulting him, because she doesn't know what the parenting is happening in the household, right? So she in a way kind of gets to play like, or she wants to play like good parent, bad parent, of like, or fun parent, wants to be the fun parent, and sent him, they've had these talks about him transitioning to adulthood, and she knows what he wants, and so she should be allowed to make those purchases with Brian's money, but not his consent. No, what I learned growing up, with my money comes my mouth. So I'm gonna have a say about what I'm doing with my money, and I feel like Brian's like,
Yes, if you want this money, it's coming with my mouth.
What happened now is because the petitioner is the one who's filed the petition to relocate and the petition for modification, he has the burden of proof, and so he goes first. So I'm going to allow him to present his evidence. He's going to be able to call witnesses and offer documents to the court. If he calls a witness to testify, you will have an opportunity to ask cross-examination questions, okay? Then once he is done with all of his witnesses and all of his evidence, then the court will turn to you, and I will hear any testimony, any witnesses you want to call, including yourself. And if you call a witness or if you testify, then his attorney will be able to ask you cross-examination questions, okay?
Yes, Your Honor.
I want to switch out to show you guys her financial statement. Okay, and then let me just... Okay, so I have up on the screen for you what she admitted for her financial affidavit. Hopefully you guys can see that fine. Is it better if I go here? Not really. Yeah, let's try me over there. Okay, so here we're just in average monthly expenses, and that is when I walked in. First of all, when I walked in the room, there's a very loud, high-pitched voice that was Sarah. I don't know if you guys can tell in the recordings, because I think that sound may have been modified a little bit, but it was just jarring. Do you know what I mean? And then the complaining and the excuses with it reminded me of Mrs. Kravitz. I know some of you guys are not old enough to remember that reference from the original television show Bewitched. That it sounded like Mrs. Kravitz. Like there's a bunch of vetching in a high-pitched voice. So that's what I walked into. And he was asking about the dental health you have to pay for and the food. So here we have the food, $250. He was asking her, does the prison not give you food? And she was like, yes, she gets 3 meals. Sometimes they're not appetizing. And he was like, what about snacks? And she said, no, don't give any snacks. And she needs them for her, I can't remember how she phrased it, blood pressure situation. She didn't say that she had, or not blood pressure, sorry, low sugar is what she said, low sugar. And I believe he mimicked her and said, so they're medical snacks, or maybe that's just, I don't know why I wrote that, medical snacks question mark. But so those are not given. And then sometimes she can't digest the meals, which I wasn't clear on what that means. Like, obviously if you don't eat it, you can't digest it, but like, did she put it in her stomach and then it come back up? It was just like, she was kind of dancing around that. But she's claiming that she's estimating that she's paid $250. It comes out through the testimony that she doesn't say it overtly, but it seems like she means this
Futuristically,
she would like to have $250 from him to spend on food, right? Which is not what this expense report is supposed to be, actuals, or at least a picture of a variance, right? If you're going to do an estimate, like I have typically spent between 50 and 100 or something like that. These seem to be like wish lists. So gifts for holidays, $100. So she specified to his attorney that those were gifts for her son. I know before she told Lana they'd also be gifts for herself, but I don't remember if she said that on the record, but definitely gifts for her son. And then medical dental for uninsured. So, and actually it's not here, but in my notes, she says she has to pay $15 a month. And then additional, like if something is actually wrong. So like if there's Tylenol that she needs, she has to pay for that. Okay. Other communication, $200. So that is her. Well, when she was questioned, she said it was communication for her son specifically. But in this estimate, it sounds like she's including all communication. It did come out that to date, Brian has paid for all of the communication she has had with her son. So she's kind of double dipping. She's saying, yeah, Brian has paid it, but then he should also pay me so that I can pay it. It didn't make a lot of sense. Like, if it's already being paid out of this hand, why do you need to move it to your hand to pay it? Like, let him just keep doing what he's doing. In her mind, it made sense though. She's just, I think, trying to get to $1,000 maybe. I'm not sure. Then he went into, so clothing. I think quarterly they're offered new clothing. Doesn't mean you need to buy it. Like, if your uniform is in good shape, uniform is what she called it, you don't need a new one. It's not like you're following the fashion trend. Like, oh, what does Vogue have out for this fall collection? Like,
Girl, it's the same outfit.
so she estimates that at $50 a month. $600 seems a lot for clothing for her. She's not like a growing girl. Do you know what I mean? Like, I have a toddler, so I'm thinking, like every 3 to 6 months I have to get new clothes for him because he's growing.
But, ma'am, I mean, unless she's growing wider, but then if we cut down on that food budget, we can also cut down on the clothing budget. See how those go together?
So the medical, dental, uninsured, 15 is as an estimate. So that's what she was like, that has to be paid every month in addition to any incidentals related to medical. Other hygiene, $50. He asked, does the prison not give you basic hygiene care? And she said it was like a 3-in-1.
So the answer is yes, they give you basic hygiene.
And 3-in-1, so shampoo, conditioner, body wash, and then she listed out it was like 1.5 ounces. So I don't know what to do with that, ma'am. But $50 a month, so she can buy. And I mean, and we saw her commissary purchases for 2024 while she was at OCCD, and she didn't buy any hygiene things. Like, what she bought, she returned. So what is she buying in there? Like, I mean, is she getting serums off of Inky List, or, like,
What?
we know she's not using face cream.
We saw you at trial, honey.
So that was that on, I believe, on all of her estimates. I had put in there $735 that she's spending. He further clarified with her, so how have you been paying for these if Brian's not sending you money? Because we find out that in 2023, that's when he stopped, when she got rid of Bankowitz, right? And so he was just like, this is never going to end. I can't keep supporting her. So he made all his filings. So at that point, she was on her own. Josh Martell is asking, like, so how are you paying for it? And she finally admitted that there were people who were giving her occasional donations, and her brother. It was very sporadic. She said she had a friend. She referred to her as she, who would, when she could, give money. So I hope all of the flying monkeys are watching, because Peter, you've given her money. Nicole, you've given her money. Christina, you've given her money. And she's reduced you to one female friend who squeaks out money when she can. We looked at the numbers in another video, and she gets a significant amount of money from her contributors. So yeah, then she added in here on this one, clothing is charged quarterly, limited quantities, fluctuating prices with vendors. Oh, when he asked her about is this what she spent? And she went into, oh, it's an estimate and it changes. The prices vary. I've only been here for 5 months. It's different so the long answer was no, she hasn't paid for any of it. And he narrowed that down by, did you pay for this with your money? And she went silent. And then I believe she asked him to repeat it. And finally she was like, sir, I do not have any money.
So the answer is no, ma'am. You didn't pay for it with your money. You can't pay for it with something that does not exist.
Then they went through the proposed parenting plan. Oh no, at some point the judge reminded her of the topics. And so we saw it in the opening statement, but what I wrote down was the proposed parenting, alimony, discontinued. They had already agreed on the child support, because she did that at the top in the opening, and attorney's fees, right? At some point she conceded to the relocation being permanent, which I don't know. I mean, I guess she could have protested it, but that would have been silly. But it's not like Sarah to not be silly, so I can't, like, discount that. You know what I mean? She was cooperative in that sense. Then they turned it over for the defense the petitioner ended their case in chief, and it was off to the respondent. So Sarah was going to do her questioning. She started admitting exhibits that she entered the parenting plan of 2018, which was when they got divorced, certificate of completion of parenting classes for both of them in April of 2018, because there was something in here she wanted Brian to retake that, even though that does not fall under any of the 4 categories. She kind of did a Lori Daybell here, where she got stuck on her answers or what she was going to say and wasn't taking in the feedback in the room and just kept going. Like when they kept objecting to Lori, facts not in evidence or something, she just went right back to her script. It just felt like Sarah had a script of like, he needs to take parenting classes, even though that was not one of the 4 topics they were meant to cover. She accused him of alienation. Again, she doesn't have any evidence of it, but said he was actively alienating her as a parent, and that he said disparaging things, restricted access to son, she didn't specify how, and was stripping her of her parental rights. All stuff from the past, right? And the judge was saying eventually, because she was going on about when she got to the citations about parental rights. Oh wait, I'm skipping ahead, sorry. So she went on about how she should be involved in his life because she knows his favorite color is red. She blames Brian for everything, basically, of like not having more time, and that he like says swear words and Brian doesn't correct him, and so then she corrects him. And
I don't know what that has to do with anything, right?
and then she mentions again the no pretrial conference. She's excluded from everything, and she used the pretrial conference as an example. She was excluded from all trial prep. It could have been resolved. I don't know how it could have been resolved, because she always has a million questions, a million complaints, no solutions, despite telling Judge Kranick,
I'm always up for solutions.
She mentioned that she was denied a gal 3 times. She's just talking at this point, narrating. She's reading some quasi poem about her son and what she does for her son. You know how she's into artistry. Like, it wasn't a rhyming poem. It wasn't a lyric, but it had like the way she read it. It was definitely meant to be poetic. I have that recording. I'll clean it up and play it for you guys. Hopefully it'll come out. But she basically is claiming like she motivates him, she inspires him, lifts him up. Meanwhile, on Brian's testimony, he was saying, sometimes he's sad after he talks to her. What her version of lifting up is and how it actually like is implanted on the child seems far like vastly different, right? She starts adding her exhibit. So she starts with number 7, which I think the judge changes it to 1, but it's her response to the May 2022 to Martell's notice, and I believe that's the one for mediation. She would like to confer. Oh, this is her alliteration. She wants to be contacted to confer for cooperation and collaboration, such a Sarah-ism. She says Brian is not following any of the current parenting plan. The judge interjects and says, would you agree that a lot has changed since 2018? When that parenting plan was created, and no one expected any criminal activity in 2020. She agrees that she has only violated it in the sense that she can't comply with time sharing, and frequently she will interject that her being incarcerated has nothing to do with this, which is silly because the reason he filed it, he states it clearly, is because she is incarcerated. So the whole foundation of the trial, the basis for the motions for elimination or reduction, the change in parenting plan, is all related to her incarceration, but she wants it to be separate, which, like, my mind, I can't wrap my head around that, because it seems very logical to me that obviously it's part of her incarceration, but in her mind that is not, like, it's like oil and water there. So she continues to say that Brian is hindering the relationship, and how many times he says he does not care. And I will say he did say that on the record, that he did not care. We'll get into that when I get the footage for the audio for the first part. But The judge can't make him care. He's not required to care about her circumstances. I just think for so many years he's come to save her and she just doesn't appreciate it. It's never enough. And so why she needs him to care, it's like she creates all this drama, right? Like she lives in chaos and she hates that he says she created chaos, but she does.
She's like this little chaos muppet.
And then she wants to suck him in and he's just like gray rocking her.
I don't care.
It's like,
I don't care.
And it's freaking her the F out, right? And so that, I'm going to go back larger since I'm not showing any more of those. So that bugs her to no end. Then she goes into her, oh my God, her citations, her case law, which was a shit show. I don't know if it was Chat GPT or something else, but I do believe there was some AI. I've watched a couple of videos recently. I think there was a judge in Michigan who was going to report one of the lawyers to the bar. He practiced in multiple jurisdictions, but he just had purely made up case law. Both she and the attorney were like, yeah, these don't exist, where they come from. And he tried to pull them up. So I think that is what her 9 third-party representatives are doing. So she started with Hunter v. Hunter, and you could tell she hadn't read any of these. She barely could read the citations. Like instead of saying third, she would say 3D or 2D, and then DCA, District Court of Appeals. Like she got it as the judge said it. But I feel like if you were actually reading these, you would pick that up, right? I mean, I have picked it up that way. So then she had Ogilvy and Ogilvy, First District Court, which was an opinion. I wrote baseless parenting. I can't remember why I wrote that. Logueria. And so the judge then started asking her for the numbers of like, what is this? And then what would you like me to know about this? And she just read verbatim the piece that she pulled, but she didn't tie it into how it related to her case. Just like in the beginning when the judge said, your opening statement, I want to know what it is that you hope to prove in this trial so I can be listening out for it, right? And so she should have tied back of like what this case, how it relates specifically to her circumstances, right? Because none of them are going to relate 100%, but like pointing out why the judge should look at these, she didn't do any of that. She did Perez v. Perez, which is about parenting plan rules. And then there was some memorandum that they removed in regard to adoption.
A child, because who's getting adopted?
Incarceration alone does not terminate rights. So the judge clarified, asked the petitioner, are you trying to terminate her rights? And they said no. And so the judge tells her, there's no argument about terminating your rights. And then, of course, she's like, well, I'm confused. Then why are we here? And we went back to the 4 reasons why we were there. And then she had Steck v. Steck, which was also another 3rd District Court. She didn't say what it was in regards to. She had the number, but I don't think she had it. Either it didn't match or it didn't make sense with the case, so it didn't actually there was no relevance. It didn't get found relevant. The judge was very frustrated at this point, and this was going slow. Like I think, yeah, it was just going slow because each time she called out these numbers, the judge pulled it up and then had to read it to Brian's attorney because for whatever reason, she didn't send her exhibits to Brian's attorney. And not that this was necessarily in an exhibit, but I mean, that came up because later on he would have to, at first the deputy was taking it from the judge to Brian's attorney. And then that just was taking up so much time that eventually the attorney just went up there to read it. So he obviously didn't have a copy of anything that Sarah was referring to. But this was taking a long time. And then shortly, that's when the CO comes on at like 4:48 and it's like, she's going to have to, get off soon. So we took a break. The judge's laptop was dying. She's in a different courtroom, she explains, and probably didn't expect it to go that long. She did not have her power cord. There was something plugged in where she could see the media on the other screen, and she thought that was meant to charge it, but she said there was another issue separate and apart that had happened to her computer, and she thinks that that is related to why it wasn't charging while showing the media. So we had a short break. I ran to the restroom because I'm pregnant, but apparently there was things overheard by Brian and his attorney, which you can get over on Hear Me Out. So then we go into, a bunch of us are all mouthing alimony to each other because she hasn't mentioned the alimony at all. All the case citations are regarding either child support, which she's already waived, parental rights. Like, none of it is really applying to none of it is applying to what we're the four things that we're here for. But
nonetheless, she moved on.
Bowen v. Bowen, she read the citation, doesn't tie it to anything. Judge was like, how much longer does she have? We're worried about the time. We're getting out at 5. Sarah then replies, well, being on the phone is difficult and I'm doing my best. I don't know how being on the phone ties you down. Maybe she has to hold it like this, and I wasn't really clear on that, but you're wasting time saying that. Like, just speed it up, right? Or give an estimate of what time it is. And why didn't you were meant to turn these in? Like, why is this not in writing somewhere for the judge to have? Oh, and when she called for exhibits that she wanted entered, every time, like, it's not like the judge has it right there, so then they have to go to the file. There's the woman that was seated. I think I told you in the other video, there's one woman that's standing like back to the right of the judge, and then there's another woman sitting with the filing cabinet open, and she's like going through. So each time she has to go through, pull it up, the judge looks at it because there's one copy, and then puts it on the whatever that's called that the judge sits at, and Brian's attorney goes up to read it. It was taking a long time. She asked about the motion for contempt for the visitation. Again, judge affirms that it was denied. There was no order for him to fill out visitation. He said she even typed it in the minutes that he would make an attempt. Then she talks about the motion for contempt for alimony. There was confusion about that. Sarah thought it was automatically included in this hearing, which is like, we're damn near the end, and the judge has already said like the 4 things off top that we were here for, and she didn't mention a motion for contempt. So why Sarah's waiting until like the last 15 minutes are left to ask this is a little perplexing. I did look at it again, and it says that the motion can be heard at the same time, like after the motion for the reduction of alimony, reduction or elimination of alimony and child support. It can be heard immediately after, or there can be a separate setting for it. So I'm not sure why Sarah was confused. She could come back with that. And I got this overall sense that she thought there were going to be more hearings, like, because she said repeatedly she didn't know they were discussing the parenting plan today. It doesn't make a lot of sense to me. Like, why did you think you were required to turn in a parenting plan, thank you, by a certain date for the trial if that wasn't being heard at the trial? And also, one of the things the CO said about when she was kind of like scolding the judge about, for the future hearings you need to do XYZ. Well, there aren't meant to be any future hearings. This is the trial. It's meant to be the end. Yeah, I don't know. I mean, the judge set the CO straight of like, there was definitely lots of coordination. I wanted her to be here in person. We've been talking about this for months, and you're wasting our time. You're eating up our time. Right? So I don't know. Anyways, Sarah didn't know they were discussing the parenting plan. She didn't know that the motion for contempt for the non-payment of alimony was calendared. And really, it can't be heard until the judge gives a ruling on if it is being eliminated or if it is being reduced. In Sarah's mind, that doesn't seem to be a possibility, that it could be either eliminated or reduced, because she has the 2018 court order. So it's like she really doesn't know why we are here today. Like, really just confused. Which is like, wow, he wrote those 33 pages.
To say what?
Then she entered as an exhibit his Truist, TRUIST bank statements. So the judge took judicial notice of those from October 18th, 2022, January 21st, 23, February of 23, and one that had no date for notice of filing, the judge said. So that is when Josh Martell popped up and suggested written closing arguments because they were running out of time. They were meant to have like 5 minutes, which is how they ended up with 5 pages, right? Because it's like a page a minute or a minute a page. He stood up and said, you know, what about if we provide our closing statements in writing by X amount of time? The judge liked that idea. We continue with Sarah and the exhibits. Her exhibit 27 becomes like exhibit 6, I think. Oh no, these actually, it doesn't have a number. Sorry. We don't, until we get to her 32, then that becomes exhibit 7. So she wrote a letter to Martell in 23. So that was objected. Again, it was the hearsay. What was it? The self-serving hearsay. So, and that was sustained. And then another objection for self-serving hearsay, and that was sustained. I didn't write down what that one was. And then she wanted the 5/12/24 letter entered, also objected to and sustained. Character witness, she had 3 letters. Objection, sustained. I don't know why she thought she needed character witness letters. And it's probably all people who know her post-murder. So what value does it really have? We would need, like, I feel a character witness from before she was incarcerated. Oh yeah, thank you. Those are my notes. Before she was incarcerated, who saw her in real life, like what kind of parent she was, what kind of person she was.
Because in jail, you can be anybody. You found Jesus, you're born again, you're whatever, you know what I mean?
Not that some people are not transformed in there,
But Sarah,
those were objected to, and that was sustained. Statutory interest rate, and he clarifies, is it just like what's published, the national interest rates? And the judge said, yeah. He said no objection, so that was entered as evidence number 7 for her. Commissary prices, no objection, number 8. I don't know why. It's not Brian's job to get you commissary, but I guess she's trying to substantiate her $250 food cost. And then current prices of uniforms were entered as number 9. Something was entered at 10. I can't make it out. So then the judge clarified they would have a week to do it. So originally she said next Monday, and then she looked at the calendar and said it's actually a holiday, Labor Day, so it needs to be postmarked for Sarah Boone by September 2nd. If it is not postmarked, as in the day it left the jail, or some sort of designation that it was on the 2nd, it will not be considered. It can be 5 pages max, and that's when Sarah was like, she said it twice. Like the first time there was no reaction from Sarah, and I think the judge picked up on that. And so she repeated it, and then Sarah was like, 5 pages? What? For the whole closing argument? And the judge was like, yes. So we'll see. Like I said, I'll read those to you guys next week. So that's what I have for my notes. I will continue to clean up the audio. I don't know. Audio might be members only, because I feel like the members are a little more forgiving if it's not perfect. I'll get it as clean as I can. Either way, the members will get it first, and then it'll be released. And then I will look for the first 2 hours. Like I said, she said she needed a couple of days, clean it up, and then she would send it to me. I love the little faces that she did at the bottom. She doesn't have to do all that. She said she could see Judge Jackson, and her face, her expressions were priceless. I will say it wasn't like she did any obvious eye rolling, but there were times where it just felt like somebody did a flash on her, like from Men in Black, and she like froze and was like, and she made eye contact with me at one point when I made a face, and then I tried to straighten my face out quickly. So I was like,
this itch is crazy, as in Miss Boone.
but yeah, so those were the notes from the second half and the opening statement. Let me know if you have any questions. I am going to do a collab with Hear Me Out. That is the goal anyway. We're trying to figure out time. Hopefully we can do it on Friday. There's still a lot. Like, I dreamt about it, and my brain is still kind of processing it all. Just the balls of a burglar, the complaints. I don't think she realizes how much she complains, and then in the same breath or the next breath will say how cooperative she was, right? What were her 3 C's of her, I think Sugar Bear ran off with that. Collaboration, cooperation. He took my other note. Just, it's so far from reality. Like, who she is actually and who she purports to be are so different. And she doesn't recognize that at all. Like the lack of self-awareness is real for someone who's almost 50. But let me know your thoughts. One of you guys asked about heirlooms, so hear me out, talked about it. The heirlooms, Brian said he personally packed up all of her things in our apartment, put them in storage. There ended up, before he let the storage go, he did go through and look for anything valuable and take that out, or memorable, like photo albums and that sort of thing. But he said there were also things like bags of old clothes. And he said maybe the stuff in storage was worth $200, which Sarah claimed was, actually, let me go back to her financial statement. What did she say? $10,000. Nothing was said about the Kia Sorento at all. We know it was scrapped. Maybe someone got in her ear and told her, or maybe when the judge went through the 4 things. I don't know though, because she still mentioned the storage stuff, so I'm not sure why she abandoned the Kia. The storage unit went from 10,000 to maybe 200, and he was like, yeah, I got it. Like, whoever you want to come and get it can come and get it. So this, yeah, she can't use any heirloom. She can't use a car. Like, you're doing life, ma'am. So of course, she talked about her appeal a million times. She talked about her pending, no, not even appeal, pending release. She's fighting to get out, as she has from day one. Well, if day one is February 25th, 2020, you're not doing a good job. You're not doing a good job. Okay. You're going to put cards in there? Oh, let me see. She's not doing a good job. And she doesn't have an attorney. Like, Josh Martell filed the extension, the second extension, but he also put in that letter, I've submitted to the lower court that I want to withdraw. So we're waiting on Kranick to respond. But for her to say her pending release when you don't even know what grounds you're appealing on just seems silly to me, honestly. And you recorded yourself murdering your boyfriend, ma'am. So you'd be going back, let's just say in some far-reaching universe, they take her appeal and they say, yes, we grant you a new trial. She's going back to Kranick with the same evidence and no lawyer. No lawyer, because why would James Owens come back? And she's reported him to the bar for not giving her her family case documents that he never signed on, never filed a notice of appearance for. You know what I mean? Like, Brian made that comment about her burning so many bridges, and we've seen it. Like, she just takes a match and gasoline and up it goes in flames. Her pending release is sketch. But, you know, I guess you gotta have some kind of hope in there. I don't know how that works. Let me know what your thoughts are. Is this as wacky as you thought it would be, or did you think there'd be a little more crazy? Well, we don't have the closing arguments yet, so just what you've heard so far, let me know. All right, I will talk to you later. Toodles. Toodles, you got it. Good job.